that a municipality has no authority to enter into a private contract with a property owner for the amendment of a zoning ordinance, subject to various covenants and restrictions in a collateral deed or agreement to be executed between the city and the property owner. Does this shock you, having just looked at planned developments with development agreements associated with them and voluntary contributions? Yeah. This is what the court said, though. And the collateral agreements have been held void in all cases to which we've been referred. Any contrary rule would condone a violation of the long-established principle that a municipality cannot contract away the exercise of its police powers. So this case is still the law, and somehow we have to understand when a development agreement is valid and when it would constitute contract zoning. So we talked about the statutory development agreement, and we presume that if it's done according to the statute, that it's valid. And we've talked about the kinds of development agreements associated with these projects, where there's a voluntary, either there's a voluntary offer to do, to contribute, or to build, or to do, and then the city is willing to accept it, and there's an agreement to ensure its performance, or there's a requirement, and the development agreement doesn't alter the requirements of the legislation, it simply creates an enforcement mechanism. Okay, so there's a difference between a contract that says, I'm going to change the law for you and only you, that's illegal, versus I'm going to enter into an agreement with you to make sure that I can enforce the law against you. A development agreement that only addresses enforcement of what is required by the regulations is generally enforceable. It's not contracting away the power to make the law or enforce the law. Is that a distinction that makes sense to you?
So I know it's a statute, but when this statute is created, do any developers have a say, or is it back and forth so they can come up with a statute? Or?
Oh, sure. I mean, I don't know the history of that particular statute, but I would bet that the development community contributed to the drafting of the statute, as well as the cities and counties through the League of Cities and the Florida Association of Counties. They probably chimed in on the legislation too, but I don't particularly know the history. Now, there's another term here called contract zoning, which is different than the kind of enforcement development agreement that we've talked about. Contract zoning is an agreement to rezone property, and that is not legal. That's the kind of thing that Hartnett is talking about. So when would that happen? If a property owner, if their neighbor got a rezoning, and then the next property owner on the street asked for the same rezoning, let's say, and it was denied, and they sued the city. And the city and the property owner decide to settle the lawsuit by the city agreeing to rezone the property. That's illegal contract zoning. They can enter into a settlement agreement that says, we'll have a public hearing, we'll consider your rezoning according to our code, and if the rezoning is approved, we'll dismiss the lawsuit. That's a fine line, but that's the important line. I've settled lawsuits between developers and local governments, and that's the difference between enforceable and non-enforceable. They cannot contract away their essential legislative power. They can enter into a contract that says, we're going to exercise our legislative power, and if the outcome is X, we're going to dismiss the lawsuit. But they're not binding their hands when they're acting in that legislative manner.
Their essential legislative power is the police power, right?
Yes, they cannot contract away their police power. So somehow the rezoning has to follow the procedure and has to be supportable and valid without any extraneous agreements. to avoid contract zoning. And I'm telling you, this is not clear. On any given day, what the city commissions may do on a zoning matter, could it be determined to be contract zoning? Maybe. But again, those things don't get challenged, so nobody really knows. But it's just something to keep in mind when if you're dealing with a property and there's a dispute, if there's a lawsuit, how you settle the lawsuit needs to, if it requires legislative action, that legislative action has to follow the process, free range. And maybe it won't settle. Maybe as a result of the new zoning hearing, they still don't approve it. Well, then your lawsuit continues. But you can't, by contract, even a contract to settle a piece of litigation, the city cannot contract away its police power. It's legislative. It's essentially discretionary legislative authority. Tricky, huh? All right.
I mean, it sounds tricky, but how many times is that actually brought up? There's probably a lot of deals that maybe fall in this category, but if nobody is challenging it to the courts and nobody's trying to bring a legal case against it,
Nobody really
just goes under the radar.
I know. It used,
especially here in Miami.
there have been areas where, okay, I remember reading a series of cases that arose in Broward County when, you probably don't remember this, when self-storage facilities first started popping up. Okay, cities hated them, and they didn't really have zoning that fit, because industrial was for like big corporate, business industrial. The idea of self-storage facilities, first of all, they thought they were ugly and would attract all kinds of nuisance things. They didn't like self-storage facilities to begin with, but then they really didn't have a zoning code that fit them. So there were a few zoning battles over self-storage facilities. And there was one guy in Broward County who invested in a lot of self-storage facilities, and he just routinely sued, and settled to get the zoning that he wanted. And the cities were happy to do it because they didn't want to go on record with their communities as approving it, but the court made them do it. They couldn't help it. It's like, I got sued. We didn't voluntarily agree to allow the self-storage facility, but we got sued, and this is the only way we could settle it. So were those settlements? It depends on how they were crafted, but who knows? But it was a facility. It was a mechanism that was used when elected officials did not want to have to go on record for approving something. So they say, well, so sue me. We can always settle it.
When I was going through the Brickell project, and when I was reading the SAP, I was saying to myself, they're leaving themselves without any checks to what's going to be happening. Then I saw later in the notes where it said they're subject to annual review.
For statutory development.
For development. And then I remember in the contract it said that if there was anything that's going to be changing, they'll get 30 days notice and a procedure for hearing and blah blah.
Okay.
So that I think would answer anybody saying that they contracted away their right to regulate what happened.
Well, and if all they do as a city, if what they do is preserve their ability to rescind or modify the development agreement for some kind of overriding public safety concern, that helps the validity of the entire agreement because they're preserving their police power, their authority to act pursuant to the police power, even notwithstanding the agreement. But later cases did allow developers to proffer voluntarily concessions to induce the approval. How to reconcile those two, I don't know. I can't always reconcile both of those lines of cases, but it's an issue in Florida law. So this is what I was talking about. Agreements to rezone and settlement of litigation are probably invalid. It's an unlawful delegation of police power. To do it properly, the settlement agreement must be structured as if-then. The city agrees to process and consider the settlement rezoning, conduct the normal hearings, and if it approves, then the condition of the settlement will be achieved. If the settlement rezoning is not approved, the parties retain all their rights to continue with the litigation. We've done this in Boca, we've done this, we've had these kind of, had a settlement like this with Pompano once.
Doesn't those litigation go on in perpetuity?
Does what?
The litigation process go on in perpetuity just to try and
Well,
stall?
you hope not, because eventually the people involved get tired of paying lawyers, so you hope it doesn't go on in perpetuity. There was a case called the Yardarm Restaurant in the city of Pompano Beach that probably went on for close to 20 years with different iterations. There was, it went all the way to building permits being approved and then building permits being revoked, and the developer sued the city. It had many, many iterations. It outlived the prime litigator on behalf of the city of Pompano Beach, God rest his soul. He was a partner in our firm by the time he died. And
That's exactly right.
it was the Yardarm Restaurant just went on and on. So,
Litigation killed it.
okay.
Bring your phone back.
Right, you're marching on. Bonus density. Have you ever, how many of you have ever dealt with a zoning situation where there was availability of bonus density? Something familiar to you? Yeah? So bonus density is something that can be cooked right into the plan and the zoning regulations. And it allows an increase in density for certain benefits. To promote whatever the local government wants to see happen, right? They can be, it's common for affordable housing. Bonus density is a common inducement to direct development to the urban core. So to get developers to focus on that urban core rather than the ex-urban or suburban land that they might be able to pick up less expensively, they can get more development bang for their buck in the urban core, so there'll be bonus density available there. You can direct development to areas with available infrastructure capacity too, with bonus development, with bonus density. And direct development to areas with mass transit. These are some of the common policies that local governments will use some bonus density to manipulate. Transfer of development rights. So this is what we talked a little bit about, the idea of air rights or TDRs. And the way I've seen it used, I've seen it used a couple of different ways. One way is to encourage preservation of natural areas. Sometimes most really high quality natural areas can be preserved simply through a permitting process. That you're just, who had the Gopher Tortoise Preserve? You guys have the Gopher Tortoise Preserve in your project? So gopher tortoises are a protected species, and their habitat is protected under regulations. So the land use regulators don't have to give any inducement to make you protect gopher tortoises because they're protected under the regulations anyway. But other less clear kinds of natural resources, maybe, you know, a pine forest or something that is valuable, but it doesn't have that kind of regulatory protected status, they can discourage development there and encourage development somewhere else that's already been scraped and cleared by using transferable development rights. They'll have you put the forest area or the preserve area into some sort of easement or restricted area. The other way that I've seen TDRs used is with historic properties, and I can't remember if we did this at lunch or if we talked about it during class. The idea that historic properties, even once they are designated, can suffer from neglect and virtual demolition by neglect, and the property owners sometimes justifiably claim that they have no way of generating the funds to keep up the historic site. They don't, it's historic, I can't use it for anything else. How do you expect me to make the money to spend on the expensive upkeep that's inherent in maintaining a historic property? So transferable development rights in Miami, in downtown Miami, this is a big feature, can be sold to other areas that are suitable for development, and a certain portion of the funds the property owner agrees to put into the upkeep of the historic building. So, historic preservation. Has anyone ever dealt with a property that had a historic designation of any variety? Any experience with it? Something here on the campus or somewhere else?
No, Alton Road, South Beach.
It's in a district. It was in what?
It was an historic overlay, and we are wanting to expand the overlay onto the last commercial corridor, which is Alton Road. And the owners there felt like, as the last commercial corridor, you're destroying my value, because it just to appease the neighbors of Flamingo Historic District, which is right behind Alton Road.
So the property owners saw the historic designation as a negative, obviously.
Obviously.
Yeah. Well, the process of historic designation is like many other regulatory processes. The first thing that has to happen is the adoption of a historic preservation ordinance that establishes what the criteria are for determining that a site is historic, determining that it's an important enough historic site to be worthy of the protection, and then a process for what that means if it's designated. What's permitted, what is prohibited, and what requires special approval to alter a historically designated site. So the typical, and I'm looking at Broward County's historic designation ordinance to get some examples. That's the exemption from taxes. So how many years? In Florida, generally, a site needs to be at least 50 years, like if we're talking about a structure, a building has to be 50 years old. Sometimes the value of the site, the worthiness of the site can be determined by someone else. If it's on the master site file at the state secretary, I think the Secretary of State's office keeps a list called the master site file of historic properties in Florida, or National Register of the Historic National Registry. If it's been designated by someone else, then the local land use folks, the local city or county commission doesn't really have to go through the process of determining if it's historic. It's been determined by someone else who's supposed to know. But local agencies also can determine that sites are historic and worthy of protection. The same kind of ordinances can apply to archaeological resources. Probably if you were in South Florida at the time, you remember what was the circle called in downtown Miami?
Miami Circle?
The Miami Circle, okay, when they were digging, they found it was associated with ancient Native Americans. Out
There was a recent one.
in Davie, going behind Forest Ridge, there is a ridge. There is the Pine Island Ridge, which is an archaeological site and historically protected site. And last year, we came out of our neighborhood in Forest Ridge and found half of Pine Island Road blocked off with lights and tents. We're like, gosh, I wonder what's going on. Well, widening Pine Island Road, they discovered an ancient, probably Tequesta, but they weren't sure, human remains underneath Pine Island Road. Now, the Tequesta Indians are long gone, and so they went to the Seminoles, and they sort of acted as the guardian ad litem for the Tequesta interest because there were no Tequesta Indians left to consult, and they ultimately decided to leave them buried exactly where they were, because that was less disruptive to the recognition of the importance of the remains, I guess, than it would have been to relocate them.
Do you know about the case of the Miami Federal Courthouse on Flagler that has been designated historical, but the building is so deteriorated and a lot of judges were getting sick in there that it was essentially, portions of it was essentially condemned. So the county who's responsible for the property, the maintenance of the building, realized that they had a problem on their hands, so they had a referendum to get funds, to get the population to agree to funding the upgrading of the courthouse and all of that, and that got defeated. So they're in a real quagmire right now.
So they have a historically designated building that they have allowed to deteriorate to the point that they can't really fully utilize it anymore, nor can they demolish it, since it's historically designated. That's not really an uncommon scenario.
Sounds familiar.
The TDR provision that I was describing is an attempt to make sure that doesn't happen. Because by selling transferable development rights, I'm doing a deal involving TDRs, and you'd think I would be able to say this word right now. It flows funds back to the owner of the historic site to ensure that they have the ability to keep it up. Okay, so the typical process for historic designation involves somebody bringing to the attention of the local government historic preservation board that a site is worthy of historic designation. Now, in the city of Fort Lauderdale, for example, anyone can start that process. They can point at their neighbor's house and say, and start a petition to have it designated historic. In other areas, it can be the city staff, members of the historic preservation board, or the owner. That may be more typical. But in Fort Lauderdale, anybody can. And I was involved in the a renovation project at the Yankee Clipper. You guys know what I mean by the Yankee Clipper? Okay? It's not the Yankee Clipper anymore. But as they were preparing that project, there were interested people who started a petition to have the site designated historic. So we were, could they have actually just been slow growth people? Maybe. It's been known to happen on Fort Lauderdale Beach with yucky old mid-century motels that they don't really care about the historic, but they just want to stop the redevelopment intensity a little bit. But eventually we were able to negotiate an agreement with the petitioners to retain certain historic features of the building, and we avoided designation entirely. But that was close. And it just would have made the whole renovation project a lot more difficult. So somebody starts a petition to have it designated historic, and there will be a set of criteria in the ordinance that have to be researched, and somebody has to demonstrate at a hearing that the property is worthy of designation. In Broward County, for example, the criteria says that a site, building, structure, object, or district that is not listed on the National Register of Historic Places may be designated only if it conveys an overall sense of past time and place by possessing at least 3 of the following attributes. And you don't have to remember this, I'm not going to touch on these criteria, I'm just trying to give you a flavor of the designation process. Integrity, location, design, setting, materials, workmanship, and association. I really don't know what any of those mean in this context. And is characterized by one or more of the following. And these are where you'll find these criteria repeated in most historic designation ordinance. That it's associated with, that events are associated with the site, that contributed to the pattern of the history of development and growth of the area, that the site or building or so on is associated with the lives of persons who were significant to the local area, that the site or its method of construction or design represents the work of a master builder, whoever that is, architect or designer, possesses high artistic values, represents a significant and distinguishable entity, the components of which may lack individual distinction. I don't know what any of this means. But these are the criteria that historic preservation architects will end up analyzing for the purpose of evaluating a petition. And then the property owner gets noticed, receives a notice that there's going to be a hearing on whether to designate their property, and there is a hearing. And these criteria have to be analyzed. And a board will make a decision of whether to designate the property. Once designated, most of you probably know this, then every building permit, with very, very limited exceptions, has to go through an additional process of review for a certificate of appropriateness from the Historic Preservation Board before you can do almost anything. I mean, you could probably paint the interior. You can do a few things without going through a Historic Preservation Board once a property is designated. So it adds to the complexity, it limits the redevelopment options of the site. But there are some countervailing benefits. It can make the property eligible for the sale of TDRs, as we talked about. It can also make the property owner may be able to get a tax, some tax relief from the property having been designated historic. So there are those two options, some tax abatement or the ability to sell TDRs, that usually, a benefit that usually comes along with a historic designation.
Is it virtually impossible to reverse a historical designation?
No, because, I mean, you can get a certificate of is it still appropriateness to demo? Let me see what it's called.
Condemned.
Demolition by neglect.
I mean, maybe what we think is historical now, maybe things change in 50 years. And,
You would need to, the designation is not reversed, but you can make the argument that you're entitled to a certificate of appropriateness for the alteration or the demolition. And it could be that it loses, through no fault of your own, it loses its historic value somehow. Yeah.
Is there a limit to the development of the rights that property can acquire?
very much.
Well,
Oh, you mean acquired or?
I mean, I think
The
so. If-
historic property, I mean, is there a limit to the development rights that it can have?
realize.
it-
You
In
mean how much they can build?
On the transferable, I mean.
Oh, transferable.
Yeah.
if there is a TDR program, it'll define how many TDR can be, whether it's square footage or, yeah, it will define it. For example, in Miami, I'm representing the owners of a historic church property, and we just got a certificate of eligibility for about 2.2 million square feet in transferable development rights. And that was using the methodology in the code there. So you calculate the maximum amount that could have been built there, and there's even a multiplier on top of that as an incentive to get people to use the TDR to fund historic preservation. So I think we might be close to a contract to sell about 150,000 square feet of the 2.2 million, but it's the largest certificate of eligibility that's ever been issued in Miami-Dade County. Maybe 2.4 million, maybe I'm losing track. And they sell for about $7 a square foot.
I was just gonna ask, is that how large the parcel is? That has a lot to do with
Yeah, it's
how
a
much
matter.
rights you get.
Yeah, it's a matter, this is located in the highest density transect in downtown Miami. So you calculate the maximum development potential, you apply a multiplier to that even for the purpose of TDRs, you couldn't do it for the purpose of building. And that's the eligibility that they have. And there's limitations on where they can sell it, has to be where it can be used. So you would have to use whatever formula is provided in the TDR program to determine what they would be. But in general, it's looking at the maximum development potential of the site, subtracting out the existing development that's historic, that's going to be retained, and you're allowed to sell off the excess. Because if it's historic, you're never going to get to use it. So that's the idea. Oh my goodness.
So is it like a credit almost?
It's a certificate of eligibility.
Right.
And if they can find a developer who wants the density, who can use the density, and agrees to pay.
I guess you get
Yeah.
yourself.
I mean, the city has its own bank of TDRs too. But, so there's a private market for TDRs and there's the city bank. And maybe, right now, the pricing is not any different between them, but that could change. You know, if there's a glut of them available, the private market price could drop, and so on. I don't know a whole lot about the tax exemption, but it's there and it's available for historically protected sites. I don't know off the top of my head how much tax can be abated, or if it depends on how much of the site is designated. I don't know too much more about that, but there is a tax benefit available. And then regulations, like I said, will apply, will control what you do with the property from there on out. And every single proposal to modify the property will go through an additional layer of review for the historic, to the Historic Protection Board. Sometimes a whole area, a whole neighborhood will be declared historic, like you were talking about, adjacent to Alton Road. There's an area, there's a whole community west of like the Broward Performing Arts Center, the Sailboat Bend area, the entire neighborhood is historic. Sometimes when the neighborhood is historic but individual buildings don't have any designation, the degree of scrutiny is a little bit lower. You can do more without approval than you could if your actual building is a historic site. Okay. 3:30. We're going to go until 3:30. Zoning. There are problems with zoning. Some of the questions, we talked about some of it early, and there was a question on the midterm. Let's get into it. What are some of the negative effects of the typical zoning structure?
It limits uses to maybe just a couple uses.
That's a negative to the property owner themselves.
Or the community.
What are these are some of the problems that are created by a typical zoning structure from a community perspective.
Reduces nuisance.
Reduces the number of uses you have, yeah, as the property owner. Let's look at it big. Even supposedly zoning is adopted for the protection of the community, right? Public health, safety, and welfare. But it's not a perfect solution. It has negative side effects, and that's what this is. That's what I'm suggesting here.
What about taxes was, I mean, will not help, like, if there is development, like buildings or whatever, I mean, would it be, would it help if, you know, the word, let's say that they can create, or can build multifamilies, in this case, they cannot do anything, I mean, it's very limited. Wouldn't help, like, tax-wise for the community? I mean, in this case, will not, because, you know, people are not there to use passing for the city.
Okay, and I want to make, let me clarify that this slide talking about the problems with zoning is no longer talking about historic protection. I changed topics. Zoning in general, this is on to like a new, just kind of a different aspect of zoning. That zoning, although it's intended for the public benefit, in a broad sense, it can have negative effects for the community beyond the historic designation discussion that we just concluded. It can have an exclusionary effect, okay? With the best of intentions, it can end up separating communities by age group, by economic class, right? If all of the multifamily is over here and all the single family is over here, do you think you're going to have the wealthier families here and the less wealthy families over there? And do you think you're going to have the good schools here and the not so good schools there? So it's intended to protect the community by maybe separating incompatible uses, but it has the effect of separating the actual people in the community unintentionally. One of that aspect of zoning, the early separation of use kind of zoning before the mixed use came into effect, it is one of the contributing factors to this suburban sprawl. That it was always cheaper to go out and buy raw land than to build in the urban core, so infrastructure kept having to get extended. Sprawl is low density, automobile dependent, high consuming of infrastructure kind of development that happens as the low density development spreads out through the urban core. Residential only suburbs, large lot zoning, all of these types of zoning regulations can often restrict the number of unrelated persons that live together. They want single family. What does single family mean? And in this day and age, what does a family mean? Okay, it's a constantly evolving concept. So there's a cultural impact to the traditional zoning regulations that alters how the community interacts, how the members of the community interact with each other, I think. Zoning can lead to really parochial, narrow-minded decision-making. It can elevate bureaucracy over that big visioning process that we saw that the legislature wants communities to go through when they adopt their comprehensive plans. When you get down to zoning, it's really fiddly, and it's very narrow and bureaucratic, and nobody's really looking at the big picture anymore as long as they can check off the boxes on the checklist. These are some of the negative effects of even a well-intentioned zoning scheme. It can result in arbitrary outcomes. I mean, one zone stops at some point and the next zone starts. Is there any real reason to treat the property on one side of the street according to one set of rules and the property on the other side of the street according to a different set of rules? Oftentimes not. But these lines, these arbitrary lines get drawn in a zoning scheme. And, you know, honestly, why do we see these planned developments becoming so popular, as you all discovered with your case studies, is a desire for creative design solutions, not a cookie cutter development. And the local governments are seeing, they're realizing that, and they're promoting the use of PDs because it allows more creativity in the project design. Inclusionary zoning, we talked about that, and you all seem pretty familiar with the idea, so we'll move through this kind of quickly. It's an attempt to create affordable housing and to mandate the inclusion of affordable housing in residential developments. In a more general sense, it may be any set of policies that requires communities to make allowances for and welcome all types of people. Apart from affordability of housing, you see this sometimes with group homes or sober houses or any kind of housing that's not traditional family housing. There are folks in our communities that need those alternative kinds of housing arrangements, and inclusionary zoning policies can be directed at making sure there's a place for them in the town. Some local governments have ordinances that require every residential development to include affordable housing in some percentage. That's what we would typically describe as inclusionary zoning. It can be subject to challenge under Dolan. Okay, is there a rational nexus between the harm that needs to be cured and the exaction, the solution that they're pushing on the developer? Other local governments have linkage fees that allow contribution associated with the development approval to go into a fund that is available to assist with affordable housing in some respect. I'm seeing, before I go on here, we're seeing some move to have linkage fees associated with non-residential development. That is, a Walmart developer who has very low wage rates is being asked to pony up because otherwise their own employees can't afford to live in the town. So I haven't really seen that get legs in South Florida yet, but there's some interest in it around the country. Zoning, there are constitutional considerations apart from the takings clause that can have an impact on the validity of zoning. Certain zoning decisions that affect speech or religious practice can be subject to a whole different level of review because of that. The RLUIPA, let me see if I can remember what it stands for. Religious Land Use and Institutional Persons Act. It's a federal law. Religious land use and institutional persons is really prisoners, people who are left, they have protection on the practice of their religious beliefs in prison. So that act says no government shall impose or implement a land use regulation in a manner that imposes a substantial burden on the religious exercise of a person, including a religious assembly or institution, unless the government can demonstrate that imposition of the burden on that person is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest. Okay, so this happens with zoning of houses of worship, of religious land uses. Are any of you familiar with the Chabad case in Hollywood? Have you ever heard this familiar at all? It was actually in the neighborhood, maybe close to Joe DiMaggio. There was an Orthodox congregation that bought several houses to conduct their religious observances, and they lived in the proximity. They tended to buy their homes in the proximity because Orthodox, part of their religion is to walk. They don't work, they don't get in a car and drive on the Sabbath, they walk to services. And if any of you know more about this than I do, please speak up. But the point was that they bought these homes and began to function as a small synagogue in the middle of a single-family residential neighborhood. And the neighborhood opposed it. And one commissioner, then on the commission in the city of Hollywood, took up that opposition, and they battled Chabad for years and years and years. In the meantime, in another single-family area of the city, there was a woman who saw visions of a Catholic saint, and that collected people to her home when she was having services, and no one in the city ever opposed her using her home as a religious shrine, and yet they opposed the Chabad. So you can see the problem with this disparate treatment of religious activities within a single-family residential neighborhood. The city got sued, they fought it for a very long time, they eventually settled, and for a number of years there was an enormous yellow sign posted in the intake, the desk where you would go to file your zoning applications in Hollywood, that notified the public that they did not discriminate, and if anyone discovered that they were being discriminated against, they should call the state attorney. It was like this big dunce hat that the city of Hollywood had to wear publicly for a number of years as part of the settlement of that litigation. So, you can't discriminate against religious exercise in the administration of zoning regulations. Regulations of speech are valid if they reasonably regulate the time, place, and manner, but do not regulate content. So this comes up in the context of the adult nightclub. Exotic dance is a form of speech, if you didn't know that. So the regulation of performances of all variety can come under this strict scrutiny. Sign regulations that purport to regulate the content of signs can come under this additional level of scrutiny because they infringe on the First Amendment speech right. Things that, where have I seen government stub their toes here? When they want to prohibit certain content, certain people from buying ads on their buses, or they want to prohibit someone from, they invite all of the community to sponsor holiday demonstrations, and they allow some religious holiday demonstrations in their park but not others. That kind of thing can get a local government in trouble on this kind of analysis. So regulations that are addressed, first of all, that treat all content neutrally will generally be fine, and they'll be valid, and they'll be upheld on that basis, because all they're doing is regulating the time, place, and manner. They're not regulating the content. And regulations that are addressed at mitigating the negative secondary effects can generally be upheld also. The adult nightclub zoning regulations fall in that. So adult nightclub prohibitions in relation to incompatible uses, or that separate adult nightclubs one from another. They can't be more than some of them condense them. They have a red light district, and they say, some zoning regulations say this is the only place in this industrial park where you can have adult nightclubs, and some of them disperse them, and they require that they be separated to avoid creating a red light district. But when those ordinances can be shown to be based upon mitigating the negative secondary effects of adult nightclubs, then they will generally be found to be valid. But if they're addressed at the speech itself, they will be invalid. All right. Vested rights and equitable estoppel. We talked about development agreements, and one of the benefits of a statutory development agreement was to create certainty for a developer that they wouldn't be subsequently downzoned, or that the city wouldn't change its mind about the approval. Cities can make mistakes, and they can change their mind, and you have to live with it, unless you have a vested right, or the facts give rise to something called equitable estoppel. So a vested right arises when a property owner expends substantial sums and changes its position in reasonable reliance upon actions of the government, such that it would not be equitable to allow the government to change its mind. The government can always discover that it's made a mistake and completely reverse itself, unless you've spent so much and you've relied on what they told you and what they did in a reasonable way, to where it just wouldn't be equitable to allow them to pull the rug out from under you. Equitable estoppel is really the same standard from the other perspective. Whether the government will be equitably estopped from changing its mind. So vested rights, a property owner may have a vested right to do something because they've expended money in reliance on the government giving them information or giving them approvals. The government, it's the same, it's two sides of the same coin. The government may be equitably estopped from changing its mind for the same reasons, because the property owner has expended substantial sums in reliance on the decisions of the government. So vested rights, equitable estoppel, two sides of the same coin. Have any of you ever seen or requested a zoning verification letter from a city? Is this anything familiar to you? Most cities and counties have a procedure that allows you to request a zoning verification. You basically identify the property, you pay a small fee, and you ask them to tell you what the zoning is. And lenders require it all the time, buyers of property require it all the time in connection with the transaction. But they actually don't have to be right. There's nothing you can rely on at all. If they're wrong, they're wrong. And paying a $75 fee is not going to get you a zoning verification letter that the city will stand behind if they make a mistake. And I've discovered mistakes in them. So it's a helpful piece of information, especially if all you want to do is make sure that the map that you're looking at hasn't been changed. So you can get useful information from a zoning verification letter, but it doesn't rise to the level of an estoppel. If they make a mistake, oh well. And eminent domain we have spent some time on. Let me see how much more. We're done. Now, at our last meeting, at our last class, we will have a little bit more lecture that obviously won't be on the exam. Any odds and ends that I think of, for example. But I will try to send you more information about the Snyder case, the quasi-judicial, site-specific rezoning case that you will be responsible for on the exam. I'll give you more information about it than we had in the slides. I don't know what happened to my slides. There is. I will definitely give you more information, and you need to know that. We'll go over a little bit more about eminent domain that will not be on the exam. We'll do the exercise in class on the land use problem that I give you, where you're going to break up into different stakeholders and different roles in the development process. You're going to consult with each other, and there'll be a development. Did I not describe this to you?
I think you said that we're gonna be entity, like a group.
Yeah. I'm going to give you a problem. I'm going to give you a fictional town and a little bit of fictional regulations and a problem, and then you're going to split up into the development group, the developer group, the developer team, the city planning staff, and the neighborhood opposition, and then maybe there was a fourth one with the elected officials, I can't remember now. So, and then you're going to sort of make the case to each other, and you're going to rotate. You're going to have to take the roles, some of the other stakeholder roles, and make the argument from the other side when the same problem or different phases of the same development problem. I think you guys gained a lot from your case studies that is similar to this exercise, but again, it gives you a chance on your feet a little bit to articulate the arguments of that particular point of view. And you need to always remember the other point of view and understand that there's truth in there, okay? They may be opposing you, but there are things that the other team needs and wants, and they're reasonable things, and you need to find a way to find a middle ground. So we'll do that exercise in the last class. Okay. Am I forgetting anything? Am I forgetting any procedural things we need to talk about? No? Okay, everybody knows what they're doing for their paper?
Hang out.
You wanna go over there?
Yeah, I'm gonna go to the other business.